And remember, if you have questions about any other legal topic, attorneys are standing by to take your call right now. As our celebration of law continues, let's take a look at more of your frequently asked questions.
If you're considering filing for divorce in the state of Oklahoma, please keep in mind that you have to live in the state for 6 months before you can file a petition. You also are required to live in the county where you're filing for 30 days before you file your petition. In order to finalize your divorce, please keep in mind that there's a 90-day waiting period if you have children, and if you don't have children, there's a 10-day waiting period.
In our last story of the night, we'll speak to DeMarco Carpenter about his wrongful conviction and his 2016 release.
We ended up getting convicted, received a life sentence plus 170 years. My heart dropped. It was like slow motion. My mom's there, my family's there, so I gotta keep smiling, staying strong. I went back to my cell and I just cried. A couple of guys that knew what was going on, hey, how did it turn out? And they convicted us, I remember being depleted, so they convicted us. So I got on my top bunk and I ended up crying for the rest of the night.
There was a drive-by shooting. There was a street party. While the kids were gathering out on the street for this party, there was a maroon car that drove past the houses and the street where the kids were gathering, turned around at the end of the street and came back. It opened fire, shooting 2 people and killing Karen Summers. There was a man by the name of Michael Wilson. Michael Wilson was kind of a known figure in Tulsa. He'd been shot 3 days before. I read a police report identifying that Michael Wilson had a maroon car that matched the description of the car that the drive-by shooters were in his front driveway the day after the drive-by shooting. He was approached by a detective from the Tulsa Police Department, tried to hide a weapon that he had on him in his bed. The officer took possession of that weapon. It was not tested until about 2 weeks later. They had a ballistic report, but that gun tested positive ballistically to the bullet fragments taken from the victim who was killed. It was the murder weapon.
The Tulsa police came to my aunt's house and asked, could they ask me some questions? I got in the car with the police. We went to the precinct on the east side. As soon as I walked in this door, I see Michael Wilson. And Michael Wilson is a guy that I knew from my neighborhood. And I said, hey man, what they got you for? He said, I don't know. He did just like that. So I said, oh. And he said, what they got you? I said, I don't know either.
Michael Wilson was allowed to say that he gave that gun to Malcolm and DeMarco the morning before the shooting, and that he had received it back from Malcolm and DeMarco and was told, to kind of keep it in his possession. Michael Wilson was allowed to testify to an accessory after the fact because he took the gun and hid it. He got, I think, 5 years or something ridiculous like that. The fact that he had the car that was identified in the drive-by shooting in his driveway the day after was never mentioned, never considered by the police.
So I went in this room along with 2 detectives, my mom and my aunt, and they was asking me questions and asking me where was I at 2 days before. It was like, well, the guy in the other room said that he gave you some bullets and a gun. I said, what guy? That guy that you just seen? I said, no, he ain't give me no bullets and no gun. I don't know what y'all trying to do, but I ain't did whatever it is. I ain't shot nobody, killed nobody. And my auntie, who worked in the Tulsa County Jail, she said he's willing to take a lie detector test. So I said, yes, I am. Even though I know it's inadmissible in court, I never took one, but they end up arresting me.
They are from a very poor area, North Tulsa, Oklahoma. They had no ability to hire lawyers. They had public defenders. They went to trial, always professing their innocence, and were found guilty by a jury in November of 1995.
December of 1995, when I was shipped to McAllister. And the day I arrived, someone was being executed. And I remember the prison being quiet. It was so quiet that it was scary. But before, when I even pulled up to the McAllister, I remember pulling up and it just looked like something from the movies. Looked scary, it looked like death. That's what I tell everybody that I tell this story. I said the McAllister looked like death.
What broke this case open for Malcolm and DeMarco is that in January of 2014, through his lawyer, Michael Wilson made contact with Tiffany Murphy, who was the then director, the legal director of the Innocence Clinic. And he basically told her, I cannot go meet my maker, knowing that there are 2 men in prison for a crime I committed. And so Tiffany, 3 days before he was going to be executed, got a videotaped confession. He identified who was with him, what they did. They were in the maroon car, that the gun was his. He never gave it to Malcolm and DeMarco, and that the men were innocent.
The Innocence Project, what we do is we review cases from people that have been convicted. We determine if there is a factual basis for their claim. And if there is, then we move forward and we'll litigate that or whatever, go through the courts with it.
I think the importance of the Innocence Network and the Innocence Movement is that it gives voice to people that have no voice. Once you have gone to trial and you were convicted, and you've gone up on direct appeal and your conviction's been upheld, I think the majority of people think, well, you know, if you can't do the time, don't do the crime. I mean, kind of shut up and sit there and take your punishment. And I think for the first time in our country, people are beginning to realize that there are people that are wrongfully convicted, and we need to listen to that voice. And so what the Innocence Project brings to people who are wrongfully convicted is a voice. We bring a voice. We listen to their case. We then become their advocates for them in court, and they, for the first time ever, get someone to listen to them and try to help them prove their innocence. It's incredibly difficult. I mean, it's the hardest work I've ever done as a lawyer, is trying to prove someone innocent.
At the Innocence Project, for the claim to succeed, we have to find new evidence that they didn't find the first time, which can be difficult to do. And we can't take it to court without locating anything new. So it could be that they're right and they are innocent, but there's just no way for us to help them. We're very limited on who we can actually help and who we can't.
It can take us 6 to 8 years to investigate. That's not before we get into court, that's to investigate a case because of all the material that has to be amassed, read, understood, and then start trying to find witnesses, sometimes witnesses that haven't been talked to in 22 years or 15 years, find those witnesses, find out if they'll talk to us, if they'll help, and only then, if we find an avenue for innocence, can we even begin to file a petition for post-conviction relief and then get into court.
It was 5 long years, because I'm like, man, what? They got on my case in 2011. What's the holdup? Why am I not released? But, you know, it was a process that they had to go through. January 29th, my sister's birthday, I have a trial, a retrial, and the judge, she didn't rule that day. She said she was going to think over the evidence and, you know, just look it in. So I sat in the county for about 3 months with all type of thoughts, emotions, like, what if it's political? What if she don't let me go because of political reasons? And what if this here, what if that, you know? I'm going home, I'm going home. The evidence was overwhelming. It was May the 9th, 2016, when Malcolm and I went there and, you know, she ruled in our favor. My attorney at the time, the director for the Innocence Project, she was tapping me. I remember her tapping me.
And I remember going, I remember looking at DeMarco and saying, do you understand what she just said?
I was like, yeah, I know what that means. I was thinking, I'm going home. So May the 9th, 2016, we was released after 22 years.
The Innocence Project bought suits for Malcolm and DeMarco because we believed in their innocence, and we wanted them to walk out of that prison with dignity. Those guys walk out, and as soon as DeMarco walks out, he looks up. He looks up. Now, I don't know if that was to give a thanks to the man upstairs. I don't know if that was to see the sun for the first time.
And I still remember it. It was beautiful. It was a nice day. You know, my friends, my family was there. Everybody was there. I was like, wow. You know, this day, I waited for this day for so long.
The best experience I've ever had in my legal career is watching Malcolm Scott and DeMarco Carpenter walk out. It was a phenomenal experience. I mean, it's that experience that keeps you moving and pushing these cases every single day, because it is so incredibly hard to save somebody from a wrongful conviction. The task ahead is vast and voluminous. I mean, there are many talented and dedicated Oklahoma lawyers that work to help free wrongfully convicted. And if there's hope, we're going to help them.
Joining us to discuss the Innocence Project are Andrea Miller, lawyer with the Oklahoma County Public Defender's Office, and Jennifer Hinsberger, Assistant District Attorney in Oklahoma County. Good to have you with us.
Thanks for having me.
Andrea, what is post-conviction relief?
Post-conviction relief is a mechanism that allows people who have been convicted and sentenced of a crime in the state of Oklahoma to go back into court and challenge their conviction based on either a change in the law or newly discovered evidence or one of several other criteria that is articulated within the post-conviction statute.
Does it have to come in a conviction from a jury trial?
No, it does not. The statute only requires that you were convicted and sentenced, so it can be either after a jury trial or after a guilty plea.
Jennifer, what types of cases commonly result in post-conviction relief?
Post-conviction can be from any type of conviction, state conviction, so anything from a traffic ticket up to a murder. Typically what we're seeing are application for post-conviction relief filed after a direct appeal, possibly claiming ineffective assistance of appellate counsel, or like Andrea said, newly discovered evidence, those sorts of things, issues that could not have been raised for whatever reason on a direct appeal.
What are the most common justifications?
Typically what we see, like I said, ineffective assistance of appellate counsel, that allows you to bring in a lot of claims that otherwise you wouldn't be able to, because obviously post-conviction is going to be the first opportunity you get to raise that. So we have petitioners claiming their appellate attorney was not effective on their direct appeal for failing to raise claims, such as sometimes there's Fourth Amendment issues that maybe weren't addressed at a jury trial or on direct appeal. Maybe evidence that was not presented or should have been discovered at that time, issues like that.
And if I could just, sorry to interrupt, just to add, we also have a post-conviction DNA testing statute, which was passed approximately 5 years ago. So we're starting to see some post-conviction DNA testing requests, meaning either there was DNA available that was never tested at the time of trial, or new DNA technology would allow more reliable DNA results.
You think that's something we're going to see more of?
I think that within this first 5 years, there have been a few petitions. I think as the law evolves on that, I do think that we'll start seeing more petitions.
Jennifer, how long does one of these actions take, typically?
It varies. Well, I should say for capital post-conviction, that's under Section 1089 of Title 22. It has its own specific statute with its own specific timelines. There is a statutory right to counsel for those, so usually it's the Oklahoma Indigent Defense System. They know their timelines, they can follow those. What we deal with at the district court level are non-capital, meaning not involving the death penalty. There really is no timeline for those, so it really is just a matter of how quickly the petition gets in and how quickly the judge rules on it, really.
About how many are filed in Oklahoma County?
We average about 100 applications a year.
Andrea, what is the remedy that is commonly sought in these cases?
Typically, when petitioners file a post-conviction application, and the vast majority of post-conviction applications are filed by people who do not have counsel, and typically they are asking for either a new trial or for the case to be, or for their sentence to be modified. But the statute itself allows for a very broad remedy for a court to be able to tailor a remedy for whatever issue is raised in the post-conviction application. So a court hearing a post-conviction application has a pretty broad discretion to decide what the appropriate outcome is.
About how often will they prevail in one of these actions?
Not terribly often. I believe probably it's safe to say 4 to 5%.
I think that's probably generous. I would say around 1 or 2% actually have claims that are successful.
Of those that are successful, what does it tend to turn on?
Often it tends to turn on newly discovered evidence, sometimes of factual innocence, sometimes witnesses will recant, sometimes there'll be eyewitness testimony for one reason or another is discovered not to be reliable. But typically it tends to involve new evidence that couldn't have been previously discovered.
Jennifer, you mentioned Title 22. Is that statute up to date considering current case law?
I believe it is. I think the post-conviction statute is written broadly enough that you can really bring just about any kind of claim that should be raised following the finality of a conviction. The only thing, as I had mentioned earlier, there's no real time limits on it. We are one of the only states, including the federal government, that has no time limits for non-capital post-conviction. So I've had post-conviction applications. I had one from 1965. Nothing actually prevented that individual from being able to file it. Of course, there were different procedural parts that applied to his claim, but as far as time bars, there really isn't one.
There is one area that our statute doesn't necessarily cover, and it involves new developments in forensic evidence. So we don't have a specific ground that would allow somebody who has been convicted on what is now considered unreliable or faulty forensic evidence, and in addition to the post-conviction statute would help kind of modernize those cases and give people a ground to go back into court on.
Although if you were able to come in and show new evidence debunking or whatever, showing that maybe that wasn't the most credible testing or whatever was done at that time, that would be, you could raise that through a newly discovered evidence claim.
It's an interesting area of the law. Andrea Miller and Jennifer Hinsberger, thank you for joining us on Ask a Lawyer.
Thank you.